Okay, we're continuing on the lecture on the Texas judiciary. This is part 2, where we're going to focus on how judges get to the bench, the selection process, the problems with partisan elections, and the suggested reforms to the Texas judicial system. As we learned last time, the Texas judiciary is primarily elected with the exception of some municipal judges. However, since the governor appoints district and appellate judges to the bench to fill vacancies prior to an election or to judgeships on a new court, there's a large percentage of judges who initially get to the bench through the appointment process. So many judges are initially appointed to fill vacancies. So this is a chart that shows you over the last several decades what percentage of judges obtain their position initially through an appointment. So these are the trial courts. So these are your district and criminal district courts, and these are your appellate courts. This is the Court of Appeals as well as the 2 high courts in the state of Texas. So you can see in the 1960s, over 50% of trial courts and right at 50% of appellate courts, those judges got to that bench because they were appointed by the governor when there was a vacancy. That went up in the 1980s to 67%. And then it starts trickling down a little bit in the trial courts to a couple years ago at 36%, and then the appellate courts to 51%. So the question then becomes, why all these vacancies? Well, some leave to get a better job. You can make a lot more money in the private sector than you can being a judge on any trial court in the state of Texas. So some leave for monetary reasons. Others leave because they've been appointed to another court. So they are always wanting to move from lower courts to higher courts in terms of a career path. And then many of the current state judges are then appointed to the federal courts when federal judgeships become available in our district. So if you remember when we talked about the federal judiciary, all those judges in the federal judiciary are appointed by presidents and approved by the Senate. And so a lot of those individuals in the federal judiciary first got their start in Texas state courts or Louisiana state courts or wherever the senator from that state is. And so a lot of federal courts in the state of Texas are people who were once part of the Texas court system. And so you can see this is why there's lots of vacancies. So how the remaining judges get their seats and how they retain those seats is highly controversial because the rest of the judges are elected. So prior to William Clements in 1978 becoming the first Republican governor of Texas since Reconstruction, Texas was dominated by the Democratic Party. We were a one-party state. And so one-party rule meant little competition for those judgeships. But since Clements was governor and then the Reagan Republicans have come in to dominate state politics, you've had a lot of partisanship through the election process when it comes to judges. All right. So an election for the Texas Supreme Court, for example, can be very costly and could cost more than a U.S. congressional race. And so this is the impression, or this is the problem illustrated by this cartoon, is that the judges, the people who are supposed to be impartial, have to seek financing for their election, and this might give the impression that they are currying favor for some segments of the population, and will that influence how they rule once they get on the bench? So this is one of the leading problems with the current way that judges are brought to the bench through the election process. Most people think money influences judicial decisions. So with the increase in competition, races become more expensive. But Texas voters do not tend to contribute to these races. So who is paying for the elections? Where do judicial candidates get money? Where is the campaign contributions coming from? They're coming from lawyers, interest groups, and other potential litigants who tend to be involved in the legal process. Furthermore, no judge is precluded from sitting on a case in which the contributor has an interest, regardless of the amount that the contributor gave. So a judge could be hearing a case where one of the lawyers gave him a lot of money for his election, and he's ruling on that lawyer's case. So even when the judicial decision is not affected, there is an appearance that such contributions factor into the decision. So some polls were taking, and 83% of the public thought that judges were strongly or somewhat influenced by contributions in their decisions. That is a very large percentage of the people who think judges could be bought, so to speak, by campaign contributions. 99% of lawyers believe it to be true, and 86% of the judges do as well. So here you have, in the state of Texas, partisan elections. People run on either as a Republican or a Democrat, so their partisanship is known. And so lawyers and other people involved in the legal process are contributing to those judges who are campaigning in a partisan manner to be a judge, and then those same individuals appear before that judge in cases. And so there is an appearance that judges are influenced by that contribution. So that's one major problem, contributions. A second problem, before I get to that, here are some of the average contributions to the Texas Supreme Court candidates. Now this is the Texas Supreme Court. This is the court that deals with civil cases. And there are a lot of high profile as well as large monetary cases going before civil courts. Think about all those class action suits where millions of dollars are at stake. So in 1980, the average for all candidates is $150,000, and you can see almost $300,000 for those who won. But you can see as time goes through, you have a lot of million-dollar campaign contributions. This is the average contribution. Okay, average contributions. And so you can see how these races are very expensive and how judges might be influenced by the fact that they get $1.6 million in campaign contributions. All right, a second problem is voter ignorance and this idea of name recognition. All right, voters tend to vote based on party label and without knowledge of qualifications of the judicial candidates. When you go into the voting booth this November, you will probably, it's a presidential election, so the first name on the ticket is going to be those running for the president. That's the top of the ticket. So when people talk about top of the ticket voting, they're looking at the top of the ballot. If they are a Democrat, they're going to vote for the Democratic candidate, and if they're a Republican, they're going to vote for the Republican candidate, and they would have heard of those two people. As they move down the ticket, there are going to be so many people running in so many different offices. At some point, people start to not recognize who these people are. It's called voter ignorance. It's not because voters are stupid. It's because they don't have enough knowledge about who's running at the bottom of the ticket for some of these judgeships. Okay? So a popular candidate at the top of the ticket might lead people to vote simply by party label. So if you're voting for the Democrat in the presidential election and the Democrat for the Texas senator, you might vote for the Democrat all the way down. That is a straight party vote. Okay. So it might be that because the judges are running in partisan elections, that people are voting simply by the party label and not by any qualifications of the judge. And so judges get elected simply because they are associated with, in a partisan election, one party or the other. Another issue about voter ignorance is the name recognition. Voters also vote based on the name game. So given the lack of information about judges' qualifications, they tend to vote for names that are familiar regardless of qualifications. Okay? So if you're familiar with someone who is running or familiar with the name, you're likely to pick that person, even if that name isn't, even if that person isn't really part of that famous family, for example. So when you think about a judge, the biggest challenge for any of the candidates for any position is name recognition. And the judges are way down at the bottom of the ticket. All right, so judges are too far down the ticket and too removed to really obtain name recognition on their own, unless their name is something famous, like Kennedy, Eisenhower, Lincoln, something that's familiar. People are going to really recognize that name very well. Okay, so judges tend to benefit from top of the ticket voting. Okay, so that's a second problem. A third problem is race and ethnicity when it comes to Texas judges. Minorities charge that they need smaller districts where minorities comprise the majority in order to get elected into office. And so what we see is a lack of representation by minorities on the Texas courts. And so you can see when it comes to race and ethnicity, the percentage of whites in the appeals, the districts, and all the way down to JP, that you have an overwhelming majority of whites on the judgeships, and you have blacks in particular who are not well represented in the Texas court system at this point in time. There's only 4 on the Court of Appeals, 5 at the district level, and you can see further down the line at the lower levels very little representation, and particularly in relative proportion to their population at large. There are a greater number of Hispanics in some of these courts than there are African Americans, but still there's an underrepresentation here. Okay, and this would probably say a lot about what happens to minority defendants on trial. Is there a race bias when it comes to the outcome of trials, for example? All right, so we have 3 problems associated with partisan elections. One is the contributions, one is voter ignorance, and then the other is the issue of race and ethnicity. So what can be done about how things are done in the state of Texas with partisan elections? So there is some prospect for reform. And so here again is another cartoon, someone running for election, and they have TV in the court. And so when you have the advent of television as well in some of the courts, you have another opportunity for judges to go before the public in terms of their re-election campaign. So what are some of these prospects for reform? Some argue that judges should only be appointed, that they should be appointed by the governor and then approved by the state senate. And many people argue that this would then release the judges from having to campaign and therefore accept money for from contributions for people who would then appear before them in court. Another option is to have nonpartisan elections. Right now we have partisan, that is, judges have to identify themselves with one party or another to get on the ticket. Nonpartisan elections would mean that there's just going to be a list for the judges and no party identification provided whatsoever. However, in cases where this does exist, like in Ohio, parties continue to dominate these systems because they are outside campaigning on behalf of those individual judges. Then there's an argument that there should be some sort of merit selection, that a committee of lawyers and lay people supply names for candidacy to a judgeship, and then the governor appoints from this list. After some certain set of time, there's a retention election. And a retention election simply means there's no opponent, that the voters are going to vote yes or no on whether to retain that judge for another term. If they retain, the judge continues. If they don't, then a new appointee is made by the governor. And that's the merit selection process. Then a 4th type of reform is a hybrid of these, which we'll just call appoint, elect, and retain. And here the governor is going to appoint through the approval process by the Texas State Senate. In the first election, the judge would run in a contested nonpartisan election, and then subsequent elections would be retention. So the person would be appointed, then he would run in an open nonpartisan election. Should he win, then he would run in retention elections and stay as a judge until voted out by the public. Well, since lawyers, judges are not necessarily inclined to change the status quo, many individuals argue for some sort of incremental change, and there's several options for these. One is lengthening the judicial term of office. Many of these folks run every 4 years, and we know the campaign cycle means you have to start running before that, so they really start running in probably the 3rd year. And so fewer elections would mean less money for campaign and less involvement of judges in politics. So that's one item of under incremental change, is to lengthen the judicial term of office. A second incremental change is the idea that maybe we should remove the judges from the straight party vote. That is, make judges be a separate section in the on the ballot to where they don't fall under the category of straight ticket voting. So then you would have less top of the ticket influence as well as less party influence. A third incremental change is to simply increase the levels of experience needed to serve on the bench, particularly in those courts that don't require legal legal experience or a license to practice law. Another change has already occurred. In 1995, the Texas legislature passed the Judicial Campaign Fairness Act, which really imposes limits on funds that candidates for state court positions can raise. And so there has been some effort by the state to limit how much money a judge can actually accept. Okay? And so there is some change coming in that direction. I won't bother you with the monetary limits. It's really not all that important for our purposes, but just know that there has been some action taken to try and limit the funds by which judges can accept. All right, so those are some of the prospects for reform. Okay. That's where we're going to conclude. You're going to have time this week to work on the extra credit assignment. I also didn't want to leave the Texas court systems without saying something about the death penalty in the state of Texas, and you should know, you probably do, that Texas is the highest, has the highest number of executions in the country, about 60% as of 2007. So this is kind of a dated graph, but still we have over a significant portion of those individuals who are put to death in the state of Texas. And we would have to consider whether or not elections to the judgeships play a role in that, and whether or not the lack of diversity on the courts play a role with that. We're going to talk a lot more about the death penalty next week when we talk about civil liberties. Okay, and so this is just to give you an idea of what's to come. All right, so that concludes the information on the Texas court system. Don't forget about the extra credit assignment, which is due on April 2nd.